remembering that basically it's all about law that has not been implemented by your member state, so the individuals cannot rely upon it in that member state, but they should have implemented it. So there's still a problem because the member state's not doing what they should be doing. So let's very briefly look at the other things before basically do a conclusion. You may know that the court's other way is very nicely called sympathetic interpretation or creation. It depends. Sympathetic interpretation is the idea, look at your national law and interpret it sympathetically. What does that mean? It means, well, the case came from a case of von Colson, but the real principle, mar leasing, it means that mar leasing is a case in a country which is not very good at implementing directives, should we say. It's Spain. Mañana? Yes? So basically, Spain at that time, probably still, are not very good at implementing directives. So what they basically do is they haven't implemented this directive, and somebody wants to use it, but they want to use it because they are wanting to say a company is void, because it is a ground that that company is no longer in existence. But it's an EU ground, it's not in their own law. But their own law, of course, has grounds when companies can be declared void. So how do you sympathetically interpret? You take your law and you sympathetically interpret it. Which means, so you've got your national law, you interpret it sympathetically, and what does it look like? It looks like EU law. So in other words, you've brought in EU law through your judges interpreting. Now, as you can probably start to understand, you're going to have differences in views of judges here. Our judges, no problem. We can sympathetically interpret because we're used to creating, no problem. But I'm not sure that's true of every system. So you are going to have differences here because it's basically putting a very large burden, isn't it, on the judiciary. You're asking them to take EU law and bring it in when the legislative body won't. And that, I think, is a very difficult burden for them sometimes to bear. But the reality is, whose fault is all this? Well, now I'm looking at a time before the Maastricht Treaty, Treaty of European Union, was fully implemented. I'm looking at a time when the European Union, if I can put it that way, had no teeth. In other words, you couldn't enforce, if you could enforce, theoretically, but if the member state ignored you, there's no penalty. So, you know, mañana, yeah, it's still mañana. And, you know, mañana is still coming. So in effect, okay, they keep taking a case and saying, do it. And the member state says, yeah, okay, mañana. And they bring it again, and it's like, well, okay, mañana. You know, there's no enforcement, there's no penalty. And I think all of us probably agree, if you've got no proper remedy, then realistically, you're going to have a difficulty, aren't you? And so there's no remedy that's actually going to motivate, if I can put it that way, member states, in effect. Well, up comes a case called Frankovich. And Frankovich brings us a remedy. Because the idea of Frankovich is something called state liability. And the idea of Frankovich is, if you cannot claim direct effect, if you haven't got in your member state that legislation, but basically it's the fault of the state, and as the Frankovich thing basically says, you've got these three requirements: the grant of right, individual rights, you can find them from legislation, and there's a causal link. In other words, you can't claim, and causally, that's because there's no legislation implemented in your country. Sue the state. It's the state's fault. Now, at the time when this particular case, the first case, the Frankovich case, was first mooted, the idea of it was horrendous. Because all the member states are going, what? We have to pay money? And how much? And when do we have to pay money? For everything? Every breach? It's clearly a big political issue. Along comes a case called Factortame, which gives us a quality control criteria. And Factortame adds that extra one, the sufficiently serious breach, basically. But now what we actually have is the idea that you've got a remedy, and you've got a number of choices. So let's go back to our Van Henge legacy to kind of conclude what I want to say. Firstly, the problem that Van Henge was identifying was what happens with uniformity, the fact you haven't got law implemented nationally, and you haven't got rights in every country. And they're giving you the start of a number of mechanisms. Direct effect that we talked about, the right to rely upon the national court. Sympathetic interpretation follows the Van Hend idea. It's trying to build this basically assembly of rights. And then we have damages claim. So in other words, you as an individual, now faced with having no national law implemented, at least have a way, sometimes, of still being able to use that EU law that hasn't been implemented, or, more likely, which hasn't been implemented well. Now let me just come to that very briefly. The problem with EU law implementation is language and system, because there's so many translations of it. And the difficulty is every language will obviously try to make it authentic to deal with the original language, French. But there's going to be differences, and it's going to depend on who funded that implementation. And did those people have the language skills to look at more than one actual treaty interpretation? So they could look at English, French and German, and then they'll try and make it Bulgarian, for example. Yeah? In other words, to try and make sure it does actually work. And if it doesn't actually work, you may find, and this is what happened in that earlier case I mentioned, von Colson, that you have the right, but you don't really have a remedy. Now, we are very practical. We say there's no point in rights without remedies, because you need the remedy, otherwise the right is simply theory. It's empty. So let me give you a very simple example from the von Colson case. It was saying, this is discrimination, yes. We have a remedy. What's the remedy? You come to an interview, here's your travelling expenses, that's the remedy, bye-bye. So are you going to have equal treatment if that's the remedy? No. Because the employer is just going to always say, I know I am being discriminatory, and I don't care, because I know what the remedy is, and that is paying your travel expenses. It doesn't work. And so therefore, quite often the problem with directives and implementation is the right is there, but it's not an efficient, effective right. And so therefore that's what we're trying to achieve. So that's the first issue, and of course we're still left with supremacy, and we know where supremacy is. It's still hanging with the courts and with that declaration attached to the treaty. But let's just really look at what else has happened. What is the real Van Hend legacy? Well, what happened immediately after the idea of Van Hend? If you're politicians and the court is starting to take away your initiative, politicians tend to start being more active because they prefer to make the decisions. And so if the court's making them without them, that means they're probably making them not necessarily in the way they want them to be. So it motivates legislators. You're looking at the practical application of things. You're looking basically at what is the real reason for this legislation and what basically do we need to make it work. Do we actually need second legislation? If we don't, let's deal with it without. We're looking at citizenship rights, which obviously are very much not part of the first part of the European Economic Community, at least as far as the member states are concerned. Now we're saying, what rights should you have? Free movement, etc. They're for people. So let's increase those rights and let's make them uniform. But we're also noting who's doing this. And it's the courts. And in the very early days, there was very much this argument, should they? But of course, you can always change what they do, can't you? If the courts do something, the legislators can change it. Have they? No. What does that mean? I'll leave that point for you to decide, because basically it's a fact and it's something you need to think about. If it was really that unpopular, if they really didn't want it, they could have changed it. Most of what this particular Van Hend legacy is has not been changed. It's still there. But it worries you when, if you're like England, you're talking about things that are closer to your heart. Judges, justice internally, immigration rights. And we think, will they do it again? Oh dear. So England at the moment is a bit, oh dear. What are they doing? Might they do it again? But of course, it's very different now. We have 27, 28 judges, panels, not the one court actively together making decisions. So it's not so easy for the court to be activist now. We see the European courts and the national courts, their relationship is changing, but they're very much a partnership. And that has obviously come about partly because of cases like Van Hend, And we've seen supremacy assessed as a practical thing, rather than as a theoretical thing, because practically you have to deal with it in a court situation. So you have an encouragement for national courts to play an active role, and most importantly, perhaps is my last point, you're motivating member states to be good, to implement, and not only to implement, but to do it well, or to face the ultimate remedy, money. Thank you. Do you want me to say something? Yes. Okay, I've been asked to say something about our course as well while you're here. As you may have gathered, in effect, we have been running this course on English and European law for many students since 1998. A couple of people here who organise this, and a number of members of your institution who are organising your whole selection of lectures are actually also alumni from our programme. And as I said, part of our idea is that you need to think practically about law and to understand, if you're talking about the European Union, that there are a couple of systems that feed in. Your system, civil system, continental lawyers, but there are the common lawyers. And the common lawyers are practical practitioners. And their methodology is very different. Their methodology is very popular, particularly in relation to commercial activities. So if you look, I was talking today to students, they have an exam tomorrow, they weren't necessarily that happy, but they were talking today about international trade law, and the question was being asked, why is it that you use English law in Russia, in Bulgaria, in China, and in England, of course, but why is it that cases, commercial disputes, are dealt with in England, using English law by the English judges? And part of the reason is practicalities, realities, in the sense that we are very practical and we try to think, predict, and put that together. So it's legal methodology. So we run a course, a 2-year program, and the idea of the 2-year program is that we will try in the first year to give you an idea of the way an English lawyer would learn law, the basic concepts of the common lawyer, the techniques, the methodology, the skills of the common lawyer. And the skills of the common lawyer include speaking, thinking, criticising, not necessarily memorising by heart. No, definitely not memorising by heart, I should say, actually. And in effect, doing writing written presentations. They are part of our traditional normal skills. So we basically try and teach our students to do that through the first year of the programme. The second year of the programme, we look at commercial activity, like international trade, like a little more detail of European law, intellectual property, and company law, corporate business law, basically, and how it works. And again, why the UK is very popular for businesses to set up business and to actually operate in the European Union. So the idea of our course is to enable students from the countries where we have centres to study our law side by side with their own law, and to understand how the common lawyers think. So going back to what I just said, if you want to do European law, you need to understand both. And you need the skills of advocacy, whatever system you're in. Legal skills are legal skills, whichever way you go, and we are very practically minded. But in addition to that, because in relation to our course structure, we have this idea of advocacy, as I said beforehand, we very much support things like mooting and practicing it, and basically doing it in a context where you have other international people also involved and discussing it with you. So we run this 2-year program. We are very happy if you are interested in starting the program. There is one thing to mention, it has a fee, so you have to pay for it. But there's also the aspect that you have an awful lot of training in language skills. Now, the English are horrible at language skills. We only learn one language. Guess which one? But we do, I have a few more, but it's not normal in our system. You, on the other hand, have language skills. You're here, you've been listening to me in English, basically. And so, therefore, learning language is one thing. Learning law language and knowing how to use it is another. So if you want to be involved in doing something commercially using English, it's another way of improving your English language skills. So I've put some details on there if you are interested in doing or looking a little more at our course. And obviously, Alex and Julie are also well aware of what we do because they're graduates and alumni, and they can tell you a little bit more about it as well if you have any interest. We're hoping to start a new program here in October, and we're now accepting applications from this time onwards, basically. So if anybody's interested, and if you have any questions you want to ask me by mailing, you're very welcome to do so. But thank you very much for your time today. Enjoy the rest of your day learning more about your technology.
Един мейлинг лист, където може да си сложите имената и имейлите и да получавате едно журналче, да го наречем, в което има доста интересни статии, които да ви привлекат вниманието и съответно да ви насочат мисленето в една или друга посока. Тук също така са оставени допълнителни материали, които може да вземете. Аз и Александър Дорич сме на ваше разположение за всякакви въпроси. Сега правим една много кратка манишка почивка от около 5 минути, просто за свеж въздух и продължаваме.